Hello, everybody. Today we are going to see about the landmark judgments in SARFAESI Act and the most important revision topics in terms of sections. If you have only 10 minutes for you to learn the entire SARFAESI Act for the examinations, then this is the video you have to watch. Today we are going to talk about the most important landmark cases in SARFAESI determined by the Supreme Court and the important sections, the days that you have to remember for your examination. So today we'll see the foundation cases of SARFAESI and the possession and remedy cases, redemption and priority cases, and the section map. What are the important sections that you have to see, and what is the numbers, timelines, and the interplay that you must remember for the SARFAESI Act. So what are the foundational cases? Like I said, the most important case is the Mardia Chemicals versus Union of India, and it is in this case the court held that SARFAESI Act is not against the Constitution. The constitutional validity of the SARFAESI Act was upheld in this case, and the only thing was it struck down the pre-deposit rule of 75% for representing or taking the case to the DRT. Instead, a representation clause was put, that is, when a demand notice was issued by the bank, the borrower can directly represent to the bank officer, and if he fails, then he can approach the DRT, and the 75% pre-deposit rule is done away with. So the Mardia Chemicals case, if there is any MCQ that asks that which case talks about the constitutional validity of the SARFAESI Act, it is the Mardia Chemicals versus Union of India case. And the next most important case would be the Travancore versus Union of India case, where it was held that a SARFAESI proceedings and an RDB proceedings can go parallelly. Just because a DRT case is pending, it doesn't mean that the SARFAESI has to wait for the DRT. The SARFAESI proceedings and DRT can go parallelly, and there is no bar on one particular process. The banks can choose whichever is the best for them, which suits them. So both the SARFAESI and DRT are complementary to each other, and the SARFAESI Act can go when a DRT original application is pending. The only thing with this is that a SARFAESI and DRT cannot take place alongside with IBC, that is insolvency and bankruptcy, due to the moratorium section in IBCs. Otherwise, a SARFAESI and DRT can go at the same time. Only during the final sale of the possession of the property, the SARFAESI or the DRT, the bank has to make an election. Now, United Bank of India versus Satyawati Tondon, here it was mentioned that, like I said, DRTs are the courts of first instance for any SARFAESI actions. However, the writ jurisdiction under High Court and Supreme Court is not austere, which means that the writ jurisdiction is present. Despite the presence of availability of the writ jurisdiction, the borrower has to exhaust his remedy under Section 17 of approaching the DRT before coming to the High Courts and Supreme Courts in under writ jurisdiction. Even then, the apex court has time and again said that High Court should not unnecessarily entertain SARFAESI writ proceedings. Now, possession and the possession was a very important thing, and the Standard Chartered Bank versus Noble Kumar talked about the ways in which possession can be taken. And the another case was Kanaiyalal Lalchan versus Sachdev, Kanaiyalal Lalchan Sachdev versus State of Maharashtra. Here they said that any challenge to Section 14 application, possession application, that is Section 14 application to DM, can be challenged under Section 17, that is under an application towards the DRTs. And RD Jain versus Subir Chakravarti. This is a very important case, but it was held that the role of the DM during a Section 14 possession application is only ministerial, which means they cannot apply the discretions. This is a very landmark judgment because when a Section 14 application is made to CMM or DM, usually they keep hearing and try and based on the hearing try and pass the orders. The Supreme Court in this case clarified that there's nothing doing. Once a possession application is filed by the bank, the DM or CMM has to pass an order. That's the only thing they can do. They cannot have any discretion about the merits of the case. ITC Limited versus Blue Coast, it talks about the borrower's right to redemption. Like I said, this is very important, very, very important that the borrower's right to redemption is lost the moment a sale notice is published, sale auction notice is published. I said the 2016 amendment, after the 2016 amendment, it was again reiterated in Celir LLP versus Bafna Motors that once the sale notice is published, the right to redemption under Section 13(8) is extinguished. So these are very important case laws. There are another case law that is about state tax officer versus Rainbow Papers, which is developing jurisprudence. We not give much ear to it. However, it is a developing jurisprudence where it was said that some state dues were in the form of secured debt under IBC. This is a developing jurisprudence. However, not much question will be asked. If in terms of case laws, the question that can be asked is which case law which talked about the constitutional validity of the SARFAESI Act or the right to redemption, uh, extinguishing, which happens when sale notice is published, and a question can be asked on the writ jurisdiction under SARFAESI. That is, usually the cases should go to the DRT, and in rare and exceptional circumstances, High Court and Supreme Court can entertain the writ petition for SARFAESI actions. However, that is not the norm, and they must actively discourage such applications. Now we are going to talk about the section map. There's the most important things that you have to understand. That is, section 2 talks about definitions, and 3 to 12 it's all about ERC registration and RBI regulations. Then 13 talks about enforcement without the court. This is the core uniqueness of SARFAESI Act, that without the intervention of court, the bankers can sell. Then section 14, that is CJM and DM's assistance in taking possessions. 15 and 16, it talks about the takeover of management and the compensation to directors. And 17 to 18 is all about borrowers' remedy approaching DRTs and then DRATs. Then compensation can be provided under wrongful possessions. Then 20 to 26 talks about the central registry, say what is the modification, rectification, and what are the priorities, and what happens if there is a delay in filing modification of security, etc. And 31 to 37 talks about exclusions, overrides, limitations, and other laws. Remember, SARFAESI Act uh, uh, falls under the limitation, and it also override other acts. However, having said that, when it comes to clash with the IBC will prevail. And it has also been held that the SARFAESI Act and RDB Act are complementary to each other, are not against each other's interests. Now, this is the most important thing that you must remember. Remember these days. Once you remember these days, the SARFAESI Acts, you become the masters of SARFAESI Act. The numbers and timelines. The numbers and timelines are very important. First, 60 days for 13(2) notice. A lender has to give 13(2) demand notice for 60 days. And within that 16 days period, if the borrower wants to make a representation, he can make a representation. and a reply to the borrower's application has to be given within 15 days by the lender. And if they are not giving, then remember the SARFAESI action can be struck down. And if it is a consortium things, then 60% of the consent to act in consortium is required. Next, 30 days is the time frame for the section 14 application. Magistrate should decide it within 30 days. It can be extendable up to 60 days. Again, this is a very important MCQ. And 45 days is the time within which, when a section 14 application is, or when something is done to take possession or to sell the property, from that day, from that date, within 45 days you can file an application in DRT if there are irregularities in following the procedure of SARFAESI. And after the passage of DRT order, if there is again borrowers' interests are not satisfied, then they can file an appeal to DRAT. That will be within 30 days. And remember, when you're filing an appeal to DRAT, you have to pay 50% deposit of the outstanding amount as claimed by the secured creditors, and it can be reduced up to 25 percentage, provided reasons are recorded in writing by the DRAT. And these are the fines. There can be 1 lakh fine for any contravention or willing contravention of the act, and 300 crores fine is for the ARCs which do not follow the recommendations, directions of the which do not follow the recommendation, directions of the RBI. That is very important. Yeah. So I'm sorry, 300 crore is not a fine. Actually, the fine is 1 crore if RBI's uh, directions are not followed. It is actually 300 crore is the net owned fund, required net owned fund for ARCs to be to operate. So these are the capital requirements of ARCs. So I'm sorry, previously I said 300 crore is for the fine. It's not 300 crores, it's actually 1 crore. Uh, that is the one thing. And the bank threshold, that is the 1 lakh. 1 lakh is the threshold for initiating a SARFAESI action. So these are very important numbers and timelines that you must remember for the SARFAESI Act. Yeah. So with this, we come to the conclusion of our lecture on SARFAESI. There are 14 lectures on SARFAESI. You can watch each on your own pace and time. And when you follow all the lectures and the questions, which is at the end of the lecture, then you would easily clear the SARFAESI part of the law officer examinations. Thank you. If you have any doubt, comment on my video. I would read all the comments and try and clarify it to the best of my ability. Thank you.